rooms at a time.
So I may stand corrected. I'm sorry. I thought I asked you if you were there when the state police was seizing the bottles, and I thought you said you were.
I was in the house, correct.
In the house, but
yes.
You weren't there when they were seizing it.
He was called in on his day off. By the time Detective Mark Mafeo left that hospital, he had collected clothing, wedding bands, and a chain of custody that the defense was about to pull apart one question at a time. Commonwealth versus Lindsay Clancy. Day 4 of trial. Plymouth County Superior Court. Case number is on the record. All 18 jurors present, including alternates. The Commonwealth's case continues, and today they are building the evidentiary foundation. The physical evidence, the chain of custody, the medical testimony, 4 witnesses, a detective, a patrol officer, 2 emergency room physicians, and a lab supervisor. On paper, a procedural day. In practice, something far more interesting. Let's start at the beginning. Detective Mafeo, spelled Mafeo, though the transcript has it a few different ways, is a 12-year veteran of law enforcement, 9 of those years with the Duxbury Police Department. On the morning of January 24, 2023, he was not scheduled to work. Detective Sergeant Jamali called him in. That alone tells you something. When your department needs to pull detectives off their day off.
Were you working on January 24th of 2023?
I was not. I was called in to work.
Okay, so who contacted you?
At the time, it was Detective Sergeant Jamali.
And is that the normal course in Duxbury when a larger incident or investigation occurs, that sometimes you'd be called in to work a scene if you're not on shift?
The incident is not routine. Mafeo was initially directed to 47 Summer Street in Duxbury. That address, 47 Summer Street, is the home of Patrick and Lindsay Clancy, the Clancy family, 3 children. And on that morning, something had happened inside that house that would send multiple people to multiple hospitals across 2 different counties before the night was over. When Mafeo arrived at the scene, the situation was still active. Ambulances present, people moving. He did not go inside the house at that point. He was told on arrival that one of the parties from the home was being transported to South Shore Hospital in Weymouth.
I did.
When you arrived there, was the scene still active, meaning there were still kind of ambulances and everything on scene?
Yes.
Did you go into the house?
Not at that time, no.
Were you advised when you arrived on scene that one of the parties was being sent to the South Shore Hospital?
Yes.
And so as a result of that information, what did you do?
I was then tasked with going down to South Shore Hospital.
That party was Lindsay Clancy. So Mafeo pivoted. He left the scene and drove to South Shore Hospital. His job at that point was to be with her. When he arrived and made his observations, Lindsay Clancy was sedated and unconscious. She had lacerations to her arms and her neck. He described this to the jury methodically, not dramatically. Just the facts.
And what condition was she when you observed her at South Shore Hospital?
She appeared sedated and unconscious with several lacerations to her arms. And
as he saw them, the prosecutor introduced photographs, Exhibits 110 through 113, the injuries to her neck, the injuries to her wrists, both arms. Mafeo confirmed each one. He was present when he observed those injuries. Whether he was present when the photographs were taken, that he could not say with certainty.
I gathered, I believe they had been removed from the hospital staff. Clothing, pants, shirt, I believe it was a scarf, and wedding bands.
Then came the clothing. At the hospital, Mafeo was handed items that had already been removed from Lindsay Clancy by hospital staff. Pants, a shirt, a scarf, wedding bands. He acknowledged that the items had been cut off of her by medical personnel. Standard practice when someone arrives in that condition. He took custody of those items. He was now holding evidence in a capital case. When Trooper Lawler from the Massachusetts State Police arrived at South Shore Hospital, along with Officer Lippard from Duxbury, Mafeo transferred those items directly to Trooper Lawler. That transfer matters. That moment is the first link in a chain of custody that the defense is going to examine very carefully. You take an item from point A and hand it to point B. Legally, every hand that touches it has to be accounted for. The prosecutor moved.
Yes.
And who arrived?
Trooper Lawler from the Mass State Police and Officer Lepard from the Duxbury Police.
And again, you had been at the scene at 47 Summer Street, correct?
Correct.
And then you went to South Shore Hospital. Were other members of the Duxbury Department at the Summer Street address and at other locations during the time you were at the hospital?
I would believe so, but I'm not positive.
And were you aware that the state police had become involved in this case?
Yes.
And based on your experience as a Duxbury officer, do you sometimes work in tandem with the state police on certain types of investigations?
We do.
And so when Trooper Lawler arrived at the hospital, did you turn over these items to him?
I did.
Quickly through this. Defense attorney Readington did not. Readington's cross-examination of Detective Mafeo had a particular quality to it. Not aggressive, methodical. He started with the clothing. He showed Mafeo photographs of the items and asked about blood. Was there blood on the exterior clothing? Mafeo said he did not see any on the items as depicted. How about the pants? He did not recall. The top? No. Then Readington asked about the bra, and here Mafeo confirmed something specific. Yes, there was a bra that had been cut off, and yes, blood had seeped through the outer clothing into the bra itself, from outside inward. Readington confirmed the direction clearly. Outside the clothing. Then through to the bra being worn underneath. Mafeo agreed.
No.
Was there a bra that was cut off, if you recall, sir?
Yes, there was.
And the blood seeped through the clothing into the bra itself? Is that correct?
Correct.
And that would be obviously from outside the clothing and then into the bra that was being worn, right?
Correct.
Correct. Why does the direction of blood transfer matter? Because it speaks to where the bleeding originated and how the body was positioned relative to the clothing. Defense attorneys do not ask questions about the mechanics of blood absorption without a reason. That detail is going in someone's closing argument. Readington then walked Mafeo through the exterior scene. Blood on the ground beneath a second-floor window. Blood on the window sill itself. One mark on that ledge. Blood on 2 shingles directly below. Mafeo confirmed all of it. He had been in the house. He had seen these things. Then Readington pressed on the pill bottles.
You'd also agree, sir, that there was blood in the area from the outside of the backyard directly underneath the window. Is that correct? Would you agree with that if you remember looking at it?
That is correct.
This way. The ground, the snow, and the leaves that were underneath. Of course, there were a lot of people walking around, but you could see the blood
Correct.
directly underneath the window, right?
The back window.
You notice blood that was on the window sill itself on the second floor, one mark on that window ledge.
Yes.
You also noted blood that at some point had gone onto the 2 shingles that were in the area underneath that ledge, underneath that window, right?
This is where Detective Mafeo's answers started narrowing in a way worth paying close attention to.
Correct.
Now, one of the things that was seized were pill bottles, is that right?
Correct.
You know why they were seized?
I do not.
Did you seize any pill bottles?
I do not.
Were you there when the state police seized the pill bottles?
I was.
Do you recall that the pill bottles were seized from, for example, in the kitchen? You opened up a cabinet and they were right on, a bunch of them lined up on a shelf.
I can't attest to that. I wasn't present for that.
Why don't I ask you this? Where did they get the pill bottles from?
You'd have to ask them. I wasn't there when they...
Readington asked were pill bottles seized during the search warrant execution. Yes. Did Mafeo know why? He did not. Did he seize any pill bottles himself? He did not. Was he present when the state police seized them? He was. But then, and this is the pivot, was he in the room when they were taken from a kitchen cabinet? He could not attest to that. He was not present for that. Readington pushed. I thought you said you were there when the state police was seizing the bottles. Mafeo clarified he was in the house, yes, but he was not in that specific room at that specific moment. I was in the house, but you weren't there when they were seizing anything. Mafeo said, correct. That is a significant concession from a detective who was called as the prosecution's witness to establish chain of custody. He was present for the search warrant execution. He was somewhere in the house. But he cannot account for where specific items were located when they were seized because the house had multiple rooms and multiple officers working simultaneously. He stayed in his area. The prosecutor on redirect tried to shore this up. Attorney Buckingham asked, did you stay to your area? Yes. Were there quite a number of state police, Duxbury officers, and crime scene troopers all working simultaneously? Yes. Each person had their own role. Correct. And you found only a laptop in the first floor closet. Correct. But Readington came right back. He asked Mafeo directly, you didn't have to stay to your area as a detective, did you? Mafeo said correct, meaning he was free to move through the house. He chose to stay in his area. But the implication Readington is planting for the jury is this: if a detective can move freely and he chose not to, then there are rooms and moments in that search that no single officer can fully account for. How many Duxbury officers were in or around that house? Mafeo could not say. More than 10. No, he would not say more than 10. State police.
You didn't have to stay to your area as a detective in the Duxbury Police Department, did you?
Correct.
So you were able to go and assist with the search and go into the different rooms and look for potential evidence, right?
That's correct.
And do you remember approximately how many Duxbury police officers were in or about the house, either outside, on the porch, on the deck, in the house, downstairs, upstairs?
I don't.
Would it be more than 10?
No, I wouldn't say more than 10.
How about state police? You remember how many there were of them?
No.
So all told, when you consider that, the sheriff's department wasn't there too, were they, if you recall?
No,
Okay,
they were
sometimes
not.
they send them to take pictures.
No.
I don't know if they, okay. Would you agree that there were probably more than 10 officers from state police and Duxbury police that would be doing this investigation?
He did not know. All told, would he agree there were probably more than 10 officers from state police and Duxbury combined? Correct, more than 10 officers, one house, multiple rooms, a search happening simultaneously across all of it. And the detective who is testifying about chain of custody was not present for the seizure of the pill bottles, cannot confirm the location they came from, and does not recall seeing journals or spiral-bound notebooks in the kitchen cabinet either. Readington closed that line of questioning with a simple question. Once the scene is cleared, people are able to go back into the home, right? Correct. And you don't know when they cleared the scene, do you? Mafeo said thank you, that's all we have. He was not thanking Mafeo, he was closing a door and leaving the jury to decide what might have walked through it. The second witness of the day was Officer Richard Lippard, patrolman.
Yes.
Once the scene is clear, then people are able to go back into the home, right?
Right.
And you don't know, I would imagine, when they cleared the scene.
Correct.
Thank you, that's all we have.
Anything on that?
Nothing further.
All right, thank you, sir.
Thank you, Your Honor.
Duxbury Police Department, 6.5 years on the job. He had finished his shift on January 24th and was called back in. His role that day was different from Mafeo's. Lippard was not involved in the search. He never went to the house. He went directly to South Shore Hospital to take over the overwatch of Lindsay Clancy from Detective Mafeo. His phrase, overwatch. She was in custody. His job was to stay with her and make sure no unauthorized contact occurred. He described her condition sedated, unresponsive, laying on the hospital bed, not speaking. At some point,
There.
Okay. And what was the purpose of you going to South Shore Hospital?
To overwatch the person in custody.
Okay, and did you learn who that person was?
Yes.
And fair to say that individual was a woman by the name of Lindsay Clancy, correct?
Yes.
What were your observations of her when you were at South Shore Hospital?
She seemed to be sedated, not speaking or anything on the hospital bed, just laying there.
the medical team decided she needed to be transferred to Brigham and Women's Hospital in Boston. The method of transfer: a med-flight helicopter. Lippard rode with her. He confirmed she was still unconscious, tubes in her mouth, bandaged, on the gurney in the helicopter. She had not gained consciousness at any point. At Brigham and Women's, she went directly into the emergency room.
Yes.
Where was she going to go?
That she was going to be med-flighted to the Brigham in Boston.
And other than yourself or other law enforcement and medical staff, did anyone speak with her at the South Shore Hospital?
No.
And when she was transported to the hospital in Boston, did you go along with the transport?
Yes.
Do you remember how she was transported?
It was a med-flight helicopter.
So you rode in the helicopter with her?
Yes.
Lippard and Officer Brick from Duxbury stayed with her. Small room, loaded with equipment, busy. Lippard described it accurately: boxes, wires, tubes, monitors.
He wasn't talking to you or medical staff or anybody, right?
Correct.
She was already had the tubes and stuff in her mouth coming out, and she was bandaged up and wrapped up and basically laying down in the gurney in the helicopter, right?
Yes, sir.
So when she gets to Brigham and Women's Hospital, they bring her into the emergency room, right?
Yes.
And that room was loaded with equipment, boxes, wires, tubes, buzzing, beeps, lights, things of that nature, right?
Yes.
Equipment everywhere. Medical staff working around them. Defense attorney Readington's cross-examination of Lippard had a different tone than his work on Mafeo. Shorter, more specific. He established that Lippard had not gone to the house at all, that he was purely hospital stationed, that he was present in a room that was, by his own description, chaos. Very busy. He confirmed that she was unconscious for the duration of his time with her. Readington asked whether she had been handcuffed to the hospital bed. Lippard said he did not recall her being handcuffed. Readington did not push it further. He had the answer he wanted: an officer who spent 16 hours in that room and cannot confirm whether a person in police custody was restrained. Lippard was relieved the next morning around 10 o'clock.
She was chained to the hospital bed too, wasn't she?
I do not recall her being handcuffed.
You don't?
No, sir.
By Officers Daly and Johnson from Duxbury. He left. He never returned to South Shore Hospital or Brigham and Women's after that. His involvement in this case ended that morning. Now, before we get to the medical testimony, it is worth stepping back and looking at what the defense is doing structurally across these two witnesses. They are not attacking the officers personally. They are not trying to make Mafeo or Lippard look dishonest. What they are doing is something more methodical. They are establishing the perimeter of each officer's knowledge. How much could this person actually see? How much can this person actually confirm? Mafeo can confirm what he collected at the hospital. He cannot confirm how the pill bottles were seized or from where. Lippard can confirm she was unconscious for 16 hours under guard. He cannot confirm whether she was restrained. Every gap in their knowledge is a gap in the prosecution's evidentiary chain, and those gaps are being carefully noted, one question at a time, for a jury that is watching closely. The Commonwealth then called its first medical witness, Dr. Mark Tenorowitz, emergency physician, Brown University Medical School, residency at UMass Memorial in Worcester. He worked in emergency medicine from 1997 until May of 2025. On January 24, 2023, he was working in the emergency department at Beth Israel Deaconess in Plymouth. His patient that evening was Dawson Clancy, the youngest child. Dawson arrived by fire department ambulance. When EMS gave Tenorowitz the report, they told him the child had reportedly been strangled and was found without a pulse and not breathing. When Dawson arrived in that emergency room, he already had a breathing tube in place. EMS had placed an intraosseous device, a needle inserted directly into the tibia.
At that time,
I was told that he reportedly had been strangled and he was found without a pulse and not breathing.
and what observations did you make of Dawson yourself?
When he arrived, he had a breathing tube in. They had placed a device into the bone of his leg to give him intravenous fluids and medicines. CPR was in progress. He was not breathing on his own, and he had no pulse and was not responding.
The shin bone, to deliver fluids and medication, because standard IV access had not been possible. CPR was ongoing. He was not breathing on his own. He had no pulse. Dr. Tenerowitz observed what appeared to be older bruises on Dawson's legs, ruptured blood vessels on his face. He did not recall visible trauma to the neck area, though he was careful to qualify that. The team worked on Dawson for approximately 40 minutes. In addition to what the paramedics had done in the field before arrival, they gave him adrenaline, IV fluids, calcium. They continued CPR. They confirmed tube placement 4 separate ways: carbon dioxide detection in exhaled air, breath sounds from the bag valve mask, direct visualization with a video laryngoscope, and an X-ray. At one point near the end of the resuscitation, Dr. Tenerowitz used an ultrasound to assess the heart directly. There was no evidence of effective cardiac activity. He did not attempt defibrillation. Not because it was not considered, but because Dawson was never in a heart rhythm that would respond to it. A defibrillator requires the heart to be in a specific state of electrical instability. Dawson's heart was not in that state. Dr. Tenerowitz declared Dawson Clancy deceased at 19:28, 7:28 in the evening. Readington's cross on Tenerowitz was brief. He asked about the older bruises on the legs.
He was unfortunately never in a heart rhythm that would have made defibrillation an effective treatment.
So your heart has to be in a certain condition for a defibrillator to even work?
Yes, there are 2 heart rhythms, basically equivalent of the heart, that if you use a defibrillator, you can restore a rhythm that makes the heart beat effectively. He was never in one of those rhythms.
And the intraosseous device, confirming that inserting that device requires penetrating the shin bone. The doctor confirmed it. Readington had no further questions. The next medical witness was Dr. Benjamin Kaufman, emergency physician at Beth Israel Deaconess Plymouth, medical school at Boston University, residency at Kings County, fellowship in global emergency medicine at Columbia. Also working the evening of January 24, 2023, his patient was Colin Clancy. Colin arrived with EMS performing CPR. His heart had stopped. He was not breathing. He was receiving breaths through a bag valve mask. As soon as Colin came in, Kaufman's team intubated him.
The first thing that we do is give a dose of epinephrine. And in this case, you can look directly at the heart with an ultrasound. And his heart started beating after we were able to give that dose. At that point, we continued compressions, continued giving him breaths through the breathing tube. And Plymouth Hospital does not have pediatrics or the ability to care for that level.
And established IV access. They gave a dose of epinephrine. Using an ultrasound, looking directly at the heart in real time, Kaufman observed the heart begin to beat after that first dose of epinephrine was administered. That is a meaningful distinction from Dawson's case. Colin's heart restarted, but he did not breathe on his own at any point. And when Kaufman assessed his neurological status using the Glasgow Coma Scale, a scale from 3 to 15, where 15 is someone walking and talking normally, and 3 represents no brain response at all, Colin scored a 3. At no point during Dr. Kaufman's care did Colin exhibit any measurable brain function. Beth Israel Plymouth does not have a pediatric intensive care unit. The moment Colin had a heartbeat.
In emergency medicine, there's a scale called the Glasgow Coma Scale, which is generally from 3 to 15. There's different variations for pediatrics, but he scored the lowest, which basically is you're in a coma or have no brain response during the entire time that he was in my care.
So on that scale, the 3 to 15, 15, would that be someone who's walking and talking and acting normally?
That's correct.
And a 3, is that someone with no brain function?
That is correct.
And you testified that Callan was at a 3 when you treated him?
At no time during his care did he have any brain function that was evident on my exam.
The clock started on getting him to a facility that could actually manage his level of care. Kaufman was on the phone with Boston Children's Hospital essentially immediately. ICU physicians there were reviewing the case in real time, making recommendations remotely while Kaufman's team continued compressions and ventilation. Colin was flown by helicopter to Boston Children's Hospital. He did not breathe on his own from the moment he entered Beth Israel Plymouth until he arrived at Children's. The helicopter crew continued breathing for him the entire way. Defense had no questions for Dr. Kaufman. The fifth and final witness of Day 4 was Melissa Arcadipane, specimen processing supervisor at South Shore Hospital. She had worked there for over 20 years. Her role, overseeing the department that received all biological specimens from inside and outside the hospital, confirmed their labeling, confirmed they were collected correctly, and processed them for testing. Her testimony was about one very specific thing: chain of custody for blood and urine samples. She explained to the jury how the system works. When a patient in the emergency department has blood or urine drawn, a nurse or technician collects the samples, places them in the appropriate vial, labels them, and sends them through a pneumatic tube system, a pressurized tube that moves sample canisters across the street from the ER to the laboratory. The lab receives them, checks the labels, verifies the correct tube type for the ordered tests, and runs only the tests a physician has ordered. Frequently, running those tests does not consume the entire sample. Leftover specimens are retained, and when law enforcement serves a preservation notice on the hospital, a formal request to hold specific samples for a particular patient, the laboratory pulls those samples, bags them separately, attaches a copy of the preservation notice, and places them in a separate bin inside the specimen refrigerator. They are physically separated from everything else, so they are not discarded during routine lab turnover. South Shore Hospital received a preservation notice for Lindsay Clancy's blood and urine samples collected on January 24, 2023. Those samples were held on January 31st, 2023, 1 week after the incident. A Massachusetts State Police trooper arrived at South Shore Hospital with a warrant to collect them.
To us.
He came with a warrant to collect the specimens.
And so did you collect the specimens that were labeled for Lindsay Clancy?
I did. Somebody had already put them in that bin in a bag, so I just went to the bin, retrieved them, made sure they were hers, and gave them to the officer.
And in fact, you handed over 6 vials of blood and 1 vial of urine to the trooper on that day, correct?
I don't remember the exact samples or sample type that I handed over, but I do know that I gave him samples.
Okay, and as far as your memory, you recall that you double-checked the ID label on the items to make sure that they belong to Lindsay Clancy, correct?
Definitely.
Arcadipane retrieved the samples herself. She went to the bin, confirmed the labels matched Lindsay Clancy's identification, and handed them over to the trooper. She testified that she double-checked the ID labels before transfer, that she was certain about. The precise count of vials, 6 blood, 1 urine, she acknowledged was in the documentation, but she could not independently recall the exact breakdown from memory. Defense had no questions for Arcadipane. The judge then accepted certified medical records for Cora Clancy, Dawson Clancy, and Colin Clancy into evidence without objection. 1 binder, all 3 children documented. At that point, the court broke for the weekend. The judge addressed the jury directly before dismissing them. He told them they were on schedule, perhaps even slightly ahead. He acknowledged that some of the breaks they had experienced were not wasted time, that counsel had been working through exhibits and procedural matters outside their presence. He reminded them that they had heard some evidence, but not all of it, that they had not yet heard the law that would govern their deliberations. He told them to keep an open mind, not to speak to anyone about the case, not to do any research, not to watch anything that might come up. He said, with a note of practicality, if someone brings it up, blame me. Tell them the judge said you cannot discuss it and shut it down. Trial resumes Monday at 9 in the morning. Now, stepping back from the testimony itself, here is what Day 4 built. The prosecution methodically laid a foundation. Evidence collected at the hospital, transferred through proper channels to state police. A scene secured before crime scene services arrived. A search warrant executed by a coordinated team. Medical testimony that established, in clinical terms, what happened to those children when they arrived in emergency rooms across 2 hospitals on the same night. Lab testimony that established the preservation and chain of custody for biological samples. That is a strong foundation. Clean witnesses. No significant credibility attacks. No dramatic moments on cross-examination. But the defense built something too, quietly, procedurally. Exactly the kind of work that does not make headlines but matters enormously to a jury paying close attention. Across 2 officer witnesses, Readington established that the search involved more than 10 officers, possibly significantly more, working simultaneously across multiple rooms of the same house, each in their own area, not necessarily observing what the others were doing. The detective who is testifying about evidence collection cannot tell you where the pill bottles came from in the house. He was not in that room. He was not present for that seizure. He found one item, a laptop in a first-floor closet. Everything else was seized by other personnel he was not watching. That is not an accusation of misconduct. It does not need to be. What it does is create space, room for a question that a jury may ask themselves during deliberations. If 10 or more officers were working through that house simultaneously, and the detective whose name appears on the evidence chain cannot confirm the location of specific items when they were seized, then what exactly does the documented chain of custody capture, and what does it leave unverified? Readington also established, through Lippard, that a woman in police custody was sedated and unconscious in a hospital room for 16+ hours under guard, and the officer covering those hours cannot confirm whether she was restrained. None of these questions were answered in the defense's favor. None of them needed to be. Not today. Today was about planting them. Juries do not decide cases based on what they are told to think. They decide based on questions they cannot stop asking. The Commonwealth closes out Day 4, having moved its evidence into the record cleanly. The medical testimony about Dawson and Colin is in. The chain of custody for the biological samples is documented. The photographs of Lindsay Clancy's injuries at South Shore Hospital are in evidence. The scene processing protocol is on the record, but somewhere in the back of that jury room on Monday morning, at least one juror is going to be thinking about a detective who was somewhere in a house with more than 10 officers, who cannot tell you which room the pill bottles came from, who cannot tell you when the scene was cleared, and who went back to his own area and stayed there. The trial resumes Monday. The Commonwealth's case continues, and the defense has already started building the question it will need the jury to carry all the way to deliberation.